SJC-11955, Commonwealth versus William Goddard.
Good morning, Mr. Sinshire. Give us a
Morning.
moment, and then we can get you started.
May it please the court, good morning. My name is Robert Sinsheimer, and I represent William Goddard. I hope it's not out of line for a young lawyer to express congratulations to the newer members of the bench. It's a different-looking bench than when I was here last time. Congratulations. I think I must begin my argument with an acknowledgement of the horror that my client perpetrated, and for two reasons. Number one, the fact of the homicide, of course, is not an issue in any way, shape, or form. And the other is that if in the course of give and take, where the questions are coming, a sentence arises that may seem to denigrate the underlying horror of the case, that's never my intent. We are never going to forget what a horrible act this was. But the question of law that I raised for your honors, at least the first one, and I think the most significant one, has to do with how expert testimony in cases where there is an insanity defense is going to be utilized. And it's a very narrow question because it's a question raised under Massachusetts law. Some of your more recent cases having to do with expert testimony have been drawn into the confrontation clause quagmire that was raised by Williams in Illinois. That's not this case, and I only bring it up because some of your more recent decisions have had to deal with that kind of question. Massachusetts law is pretty simple. It's Rule 705. You said so in the case of Commonwealth versus, I think it's pronounced Jaime, J-A-I-M-E, 433 Mass 575, and that's also on point because it had to do with psychiatric testimony.
I'm failing to see the analogy with Jaime. What Jaime had to do with was that there were hearsay statements, out-of-court statements, that shouldn't have come up in direct examination.
Right.
And the information came through the expert's testimony about the hearsay that could be the basis for the testimony because it would have been independently admissible. What we have here is a whole bunch of unobjected to evidence that is uncontested, and your narrow objection seems to be that the expert says that the killing was planned. And so it's very different than Jaime. This is distilled down to a appellate issue of whether or not the expert can testify that the killing was planned.
Well, I agree with your honor in the sense that it is a narrow issue. I don't necessarily agree that Jaime isn't helpful. I agree with you, it's not directly on point. I think this is worse than Jaime.
This is an expert testifying to information not within his personal knowledge. That's not objected to. It's implicit for the jury that she doesn't have personal knowledge. It's implicit to the jury. But she's testifying about information that she knows nothing about, that she has no personal knowledge about. There's no objection to any of that, and it's all uncontroverted. This is not hearsay. This is lack of personal knowledge. Jaime is completely indistinguishable from this situation.
Well, on the hearsay point, I think you're right, but I don't agree that first of all, there was a very strong objection because the specific question that was asked was, and I have it here, based on your review of the material and so forth, do you have an opinion as to whether or not on January 28th, Mr. Goddard engaged in goal-directed behaviors? Right. Now, I guess, Your Honor, Justice Lowy, technically the real question is what is the valid subject of an expert opinion? And an expert opinion ought to be about medicine, at least if it's a medical expert. And a psychiatrist is a medical expert. And it ought to be about nothing else as far as the opinion. And I don't think this is just a semantic distinction. I think it's a real distinction. When you start bringing these experts up and they start talking about what the person did. Now, I think what makes this particularly troubling, of course, is that the element of premeditation is a crucial element in the distinction between first and second degree murder. In this particular case, it was the only one. So you've got an expert who is essentially asked, did he premeditate? Because at least in my humble view of the English language, to use the phrase goal-directed and to use the phrase premeditation, it's practically the same thing.
Well, his expert testified to the same thing, though, right?
No,
I thought that, if I'm not confusing my cases, was his expert Dr. Brown?
yes.
Okay. Didn't Dr. Brown say that his behavior was goal-directed?
He may have said it in that sense, but there was no objection from the Commonwealth side, and I think that two wrongs don't make a right, first of all.
Well, it goes to the issue of prejudice, I guess.
It does go to the issue of prejudice, and the issue of prejudice, let me raise that, jump ahead a little bit. I think it's significant because we are talking about experts. And the government did a really good job in its brief of pointing out, there was a lot of evidence of premeditation, quite apart from whether or not they had an expert. But here's the point, Your Honor. They argue that it's cumulative. If it's cumulative, why break the rules? And the answer, in my mind at least, not suggesting that there was malfeasance, just strategically, is they want it to come from the expert. And that's what's not fair. And that's what makes it more than cumulative, because an expert is a completely different type of...
Mr. Sinsheimer, how does a Commonwealth expert or any psychiatric expert testify about dissociative episodes if somebody doesn't know what they're doing without using language such as goal-directed?
I think the expert could have been able to say that there is evidence that has been testified to that has the appearance of goal-directedness, or that she could say, based on what she read about the crime itself, there is, but the real answer to Your Honor's question is really this. The expert is not to testify to facts. And I think your opinion rises and falls on whether or not you believe, this goes back to your question as well, Justice Lowy, whether or not you believe, as I do, that the question was a question of fact, and it was sort of a mixed question. I want you to give us an opinion about a key fact in the case, as opposed to, I want to give you an opinion about medicine. Now, let me answer Your Honor's question more directly. Do you have an opinion as to whether or not, on such and such a point in time, Mr. Goddard had the capacity to premeditate? And the answer would be yes. What's the basis of your opinion? All the evidence in the case. And sit down. One of the problems I think we're facing, and this gets back to Justice Hines' question, did the defendant commit a similar error? Perhaps. There's too much psychobabble going on in these cases. And I think no matter which way the decision falls on prejudice, Your Honors have to do something to tone that down. And I trust in this opinion, at least we've raised an issue that's worthy of you taking a look at how wild and crazy, if you pardon the colloquial language, some of these insanity trials have gotten. I think a criminal trial should be more than just a mudslinging, it's not mudslinging, but a battle between two competing, I use the phrase psychobabble, two competing professionals who are willing to give speeches instead of answer questions in accord with the laws of evidence. We have laws of evidence for a reason. And Rule 705, in my judgment, in my suggestion anyway, was clearly violated in this instance. And I do think, getting back to Justice Lowy's original question, that Jaime is helpful. I also think it's very clear that none of the cases that they cite support this kind of question. The phrase, quote, goal-directed, end quote, has shown up in opinions, and two in particular that we've distinguished, Boateng, B-O-A-T-E-N-G, and Goudreau. In both those instances, it wasn't a direct question like this. In one, I believe it was Goudreau, the expert was testifying, he was goal-directed when he sat down with me. That's very different from saying, I know he was goal-directed out on the street. It's very, very different. And in Boateng, it came up in passing. But the only actual opinion offered was an offer as to competence. So to sum up this section of the argument, it seems very clear to me that this expert was asked to tell the jury the key fact in the case. The question is no different in my mind than, Ms. Expert, do you believe that this defendant premeditated? I think if that was the question.
That would be objectionable, not because it goes to the ultimate issue. There's no problem with an objection going to the ultimate, a question going to the ultimate issue. The problem with that question is it's not helpful to the jury. The expert could be asked, did you have an opinion as to whether the defendant had the capacity to formulate the intent necessary to kill? It's not a issue of it going to the ultimate issue in the case.
Well, I think that's part of the problem. I think the way you formulated the question just now is exactly correct. If it had been done that way, I wouldn't have this argument. But that's not what the question was. The question was, do you think he acted in a goal-directed manner? And I suggest to you respectfully, Your Honor, that that's the same as saying, do you think he premeditated? And they shouldn't have a right to get premeditation out of an expert. And I guess I'm going to repeat myself a little bit. I mean, there's a lot of other evidence in the case, but I don't think it's cumulative because it is an expert. And then Mr. Doolin jumped right up and objected as he was supposed to do. And so I think it's a very, very clear violation of law that was incredibly prejudicial, at least as to that jump from second degree to first degree. You know, I'm not suggesting that this guy walk away. I'm suggesting that based upon our important rules of evidence that apply to everyone, even the worst of the worst, that this element of premeditation was presented unfairly. And I ask Your Honor to review that. Now,
I've not looked at her testimony, Dr. Fife, so I don't know the context of it. Was the context of this question leading up to an opinion that he was capable of conforming his behavior to the law, or was it a preface to an opinion to say that he was capable of premeditating?
That's a great question, and I actually looked.
All my questions are great.
I appreciate that, Your Honor, and I'm
Some-
well aware.
some
I'm
greater
also
than
well
others,
aware of
some
that.
greater than
And
others.
Maybe my better answer was I'm stalling because I can't recall exactly, even though I read the transcript last night. But I can say this: what I can recall is she did get the appropriate expert opinion. They got out what they needed correctly. That's why they didn't need this. It was totally out of line.
But to the extent that, I think, again, we'll hear from Ms. Lazar-Moore. I think that they were leading up to, my memory is that there was no dispute that he knew the difference between right and wrong. So we're focusing on the second prong of insanity, which is whether he was capable of conforming his conduct. And if you are pursuing a goal, and if your conduct is goal-directed, that does go to the issue of whether you're capable of conforming your conduct to the law. So why is it not sort of a preface to the ultimate opinion on that second prong of insanity?
Because it's not something she can opine on. She could say that there is evidence that he acted in a certain way, but the problem here, Your Honor, again, and at the risk of repeating myself, is, you know, an expert doesn't have free rein to, because they've studied the case, give the Commonwealth's closing argument prematurely. The expert's supposed to opine about medicine, and to say someone acted in a goal-directed way has nothing to do with medicine. It's like a closing argument. It's a summary of the other factual evidence that the government was able to introduce. To ask someone whether they had a mental capacity, that is, in fact, an appropriate question, and that gets back to the question that was asked later. And I suggest to you respectfully that this type of questioning is completely out of line, and it was prejudicial, again, because it went so clearly to that element of premeditation. So I'd like to move on quickly to the closing argument segment, and I'll be very brief about that. The gentleman, the defendant, left a CD-ROM in his car in which he had made some statements to the effect ahead of time what he was going to do. The tape, I guess it must have been a horrible tape, begins with a phrase to the effect, if you're listening to this now, I must have done what I set out to do, something to that effect. But there's no clear evidence as to when that was made. And given that premeditation was the primary issue in the case, for the Commonwealth's attorney to stand up and say, well, we know or we're pretty sure it was made right before the homicide, I suggest...
Didn't the defendant testify that his side of the story was on the CD?
Yes. Well, he didn't testify. Excuse me.
Well, his statement. I'm sorry, yeah.
But did
I do know what you mean. That's why I
But
shouldn't be
didn't
so
the CD
picky.
didn't the CD make a reference to troubles he had with the victim last year? And since the killing was in January, on January 28th, last year infers that it was made in January.
Correct, and I acknowledge that in my brief, but that's what, but also, if this guy was as wacky as I think he is, he could have made it, you know, in December, you know, just
Right.
to have it
He
around
could
in
have-
case he decided
He
to.
could have been in error, but it's certainly not inappropriate for a prosecutor, when you say this happened last year, to say that I take the defendant for his word, and I can infer that this was done in January because the events occurred in October of 2007, and that would have been last year, and
Yeah, but that's not what he said. That's the problem. He said it was right before the homicide, and that's,
January 28th, so if it was
Yeah.
last year, it had to be sometime in January, so, okay, so it's within 28 days.
well, you know, I guess it comes down to what is recency. Anyway, I will rest on the brief with respect to that argument unless there's further questions on that particular. And then in light of the totality, everything I've said, I don't think I need to repeat myself. Under 278, Section 33E, I think the fairest way to proceed is to just knock this back to second, or as you did in a recent case. And I hit on this actually just this past week, and I can't recall which case. I think it might have been Aristotle, but one of the cases that came down on this, of this nature, Your Honors actually gave the Commonwealth a choice. You can either try the case, you can either try it over, or you can accept the second degree. I think that would be an option for this court. If I may summarize, I'm still ahead of my time. All I ask, Your Honors, regardless of which way you come on prejudice, I know that's a close question, that this narrow question is an important one for those of us that actually are trying cases, to see if we can't put some more clear boundaries on the type of testimony that these psychiatrists on both sides seem to want to be able to spill out. I would point out, by the way, if you read her entire answer, it's very clear that this witness had a personal agenda. And she practically says so. She, well, I'm going to start talking now, but if I get out of line, stop me. You know, that's not trials. That's not the way it's supposed to be. So I ask Your Honors to take a close look at this and reverse the conviction, order a new trial, or in the alternative, suggest that it's a verdict of second-degree murder. If there are no further questions, I will conclude my argument.
Good, thank you.
Thank you very much.
Ms. Lazar-Moore, good morning.
Good morning. Excuse me. Ellen Lazar-Moore for the Commonwealth. This court should affirm the defendant's convictions because the Commonwealth's expert properly testified regarding facts she considered in reaching her opinion, where all of those facts had been admitted in evidence, not only through the Commonwealth's witnesses, but also through the defendant's expert, and none of those facts were disputed by the defense.
Is it a better question to ask about capacity to engage in goal-directed conduct, whether versus engaged in goal-directed conduct?
Your Honor, the way the question was asked, the prosecutor asked, based on your review of the material, the investigation, et cetera, do you have an opinion whether Mr. Goddard engaged in goal-directed behavior? I suppose he could have phrased it whether Mr. Goddard had the capacity to engage in goal-directed behavior, but I think that in context, it would have been clear to the jury that The expert, as Justice Lowy remarked, didn't have personal knowledge of exactly what had happened. She was not there for the crime, but based upon her review of everything, her interpretation of the evidence was that the defendant had the ability to plan and carry out the crime. And it was a prelude to giving her ultimate opinion on the defendant not having a mental disease or defect and also having the capacity to appreciate the wrongfulness of his conduct and the capacity to conform his conduct to the law. If you look at her answer in context, she says it was her opinion that his behaviors were planned, but then she goes on to say they were well organized, they were not disorganized. When he was found, he wasn't a mentally ill person, disorganized, thought disordered, speech disorganization, manic, psychotic. She fleshed out that answer to explain why, in her opinion, based upon her review of all the evidence that was already before the jury, he did not have a mental disease or defect, and he had the capacity to conform his conduct to the law. So I believe that this testimony was appropriate and that there was no error.
Now, with regard to his complaint that we need to rein in a little bit, she did wander a bit in her answer.
It was a little bit rambling, but Your Honor, again, there was no objection to that portion of the testimony, and all of the facts that she touched upon were facts that were in evidence and had literally just been discussed by the defendant's expert, Dr. Brown. And so, although part of it does come across a little bit as sort of thinking out loud, I believe it seemed to me that she was trying to put into layperson's terms something that the jury could understand what her expert opinion was. And I don't think that it went beyond what was permitted by the law, most important of all. As to the defendant's challenge to the closing argument, that too was proper. When the prosecutor argued that the defendant made his recording in January closer in time to the killing than he had told his expert witness, this was based upon the defendant's own statement on the recording about what had happened last year, quote unquote, in October. And also, if you listen to the recording as a whole, it appeared to lay out a plan that the defendant had then carried out. So I think it was a fair inference from the evidence that the defendant had made the recording in January, closer in time to the killing, rather than in mid-December, and just put it away, as Dr. Brown had claimed.
I just want to go back to the broader point that the appellant made, that Chief Justice Gantz just touched on. I think that the appellant's point is that perhaps experts have to be more careful in these cases when you have experts as it goes to issues of mental states, as to whether or not they're testifying based on personal knowledge or whether they're testifying based on assumed evidence. Now, we don't want to go back to the days where hypothetical questions or assumed facts have to be a preface to the question. But the problem is that when the expert just starts testifying about the facts, that oftentimes you have a defendant who's been interviewed, and that interview can't come out as part of the basis of the opinion. And it's hard for the jury to be able to discern whether or not these assumed facts include within it what can be a basis for the opinion, but can't come out on direct. And so I think that's the appellant's point, that this needs to be a little bit more care in the manner in which these questions are answered.
Perhaps, Your Honor, although I didn't really read the defendant's brief as raising that point.
I didn't read his brief that way at all. I didn't read his brief that way at all.
Yeah.
That's how I heard his argument.
Okay. And again, there's no question that the doctor's answer here did tend to go on for a while, but I think, again, that all of the facts that she mentioned, each and every one of them, were in the evidence. This was not hearsay that was admissible but not admitted, which is what's talked about in the DYS case. These were facts that had literally just been talked about by Dr. Brown, the defendant's own expert. And so I don't think there's any concern here that the jury would have thought that this was something that the doctor knew, but they didn't know what the source of it was. There was no dispute that the crime had occurred in this particular manner. The particular facts that the doctor referenced here and that Dr. Brown also referenced were the killing, the fleeing the killing, the being stopped by the officer who was working a traffic detail, going to the friend's house, and then fleeing the friend's house. Literally, those 5 items. That's what Dr. Fife talked about in that one answer, and Dr. Brown had talked about those exact same things. And the jury, most importantly, had already heard all of that evidence, which was undisputed.
This would be a harder case if, as I assume, this witness, Dr. Fife, was not testifying in rebuttal. I didn't read the transcript. Was she
She was
testifying as a
testifying in
rebuttal
rebuttal,
witness?
yes.
And this kind of testimony would definitely cause problems if she were not testifying in that capacity. So in a way, it seems as if she's forgiven somewhat by the timeline of her testimony.
Well, I think it still would have been proper, even if it wasn't in rebuttal, or let's say the defendant didn't have an expert, because it was all based on evidence that had already been admitted that was undisputed. But certainly the fact that the defendant's expert had relied upon and just mentioned all of the same evidence changes the context a bit.
Okay, thank you.
Thank you.